Hello, everyone. My name is Troy McKenzie. I am the Dean of NYU School of Law, and thank you for joining us on this wonderful occasion. It is my honor today to welcome you to this unveiling of a magnificent portrait of a magnificent figure in the law, the late Chief Judge Judith S. Kaye. It is an honor and a privilege to bring you here for this portrait unveiling so that her portrait can join other luminaries of the law with a connection to this law school. We are also particularly grateful to Jamie Lee McMahon, the Memphis-based artist who captured Chief Judge Kaye with such tact and depth as we will see shortly. To have a portrait of Chief Judge Judith Kaye here is quite meaningful. It signifies to all of us who inhabit these halls that her life and career were ones that we should all strive for. She defied many barriers to enter within the elite parts of the law and the judiciary. She was born to immigrant parents, and she then worked as a journalist before attending NYU Law, where she had to work her way through school. Nevertheless, she graduated with an exceptional record as a member of the class of 1962. She then began her career in private practice at the law firm of Sullivan and Cromwell. She then later joined the IBM legal department. While raising her family, she also worked as a part-time assistant for the dean of the law school back at NYU at one point. She was then hired by the law firm of Olwine, Kelly, Connolly, Chase, O'Donnell, and Ware as a litigation associate, rising to become a partner in 1975, the firm's first female partner. I think we all know her best from her time on the New York Court of Appeals. She was appointed to that court in 1983 and later rose to become Chief Judge. We are grateful for her dedicated service throughout her career, and she really did set an example for our students and others to follow along the way. A point of personal privilege, I just wanted to note how meaningful it is to me personally to have this portrait here in Vanderbilt Hall and in this room. The last time I remember talking to Judith was here in this building when the Historical Society of the New York Courts was hosting a program at the law school together with the Supreme Court Historical Society. We welcomed the Chief Justice of the United States, who was speaking across the hall in Tishman Auditorium. This would have been, I think, in maybe 2014 or 2015. I can't remember the exact year. But I was about to go off into a couple years of government service. And I remember sitting across the street in a cafe talking to a couple colleagues before the event began. And out of the corner, I heard her voice, and she walked over, and we had a lovely conversation about the event, about the Historical Society, and about the law school. So she is deeply, deeply missed. We have a number of speakers this evening, and I would like to begin by introducing those who are going to be speaking. First, we will have the privilege of hearing from the Honorable Jonathan Lippman, former Chief Judge of New York. He is currently of counsel at the New York office of Latham and Watkins. As you all know, Chief Judge Lippman was a dynamo as a member of the Court of Appeals from February 2009 through December 2015. And during his tenure, he authored major decisions across many, many areas of constitutional law and statutory and common law as well. In particular, he championed equal access to justice in the state and around the country, and took leadership roles in identifying permanent funding streams for civil legal services. So I would like to welcome Chief Judge Lippman to come to the microphone.
Thank you, Dean, for that introduction, and thank you for inviting me here tonight. You know, as with myself, but even more so in her own way, Judith Kay had a special affection for NYU Law School. She would be so thrilled to know what was happening tonight here at the law school. You know, no matter what came up, and all of you who know of her relationship to NYU, anything, no matter what she was doing, she dropped everything. If there was anything to do with the law school, she was there. Nothing really gave her more pleasure than to be in this room, you know, Greenberg Lounge, with her NYU family. She loved being introduced by the various deans, John and Ricky and everybody else over the years. She'd be thrilled that Troy is introducing this program today. And it's fitting that we do an unveiling of her portrait here in this great law school, her law school. Judith Kay was a chief judge in the tradition of John Jay, Benjamin Nathan Cardozo, all of the giants of New York jurisprudence. She was a little different than the others before her in that she wore red shoes. And Benjamin Nathan Cardozo, as far as I know, you know, so she was singular in every way, and her impact on the court, the High Court in New York, was so great, and again, in so many different ways. Early on, she was a champion of state constitutional rights. She really started a revolution in high courts around the country in recognizing that sometimes state constitutions have far better, stronger guarantees of rights than under the federal Constitution. And this continues even today. I don't know if any of you saw last week, there's an article in the New York Times about how important state high courts are, in particularly in interpreting the state constitutions. And the idea was that whatever was happening in the federal government, look to New York or whatever state it is and see what our founders, what the people who started New York, what they had to say in terms of human rights and rights for everybody. This was a visionary concept. She burst onto the screen nationally over that particular issue. And legal scholars sort of took it to heart and got it. And so who is this person who this was such a strong, again, almost revolutionary idea about the rights in each of the state's constitutions, and particularly here in New York. She also championed the idea that New York's highest court should speak with one voice. In her mind, you strive for consensus above everything else, because it makes the law more clear for the public and for the bar. And as at least one person here tonight would know, she'd go around that table at the Court of Appeals and say, let's do it one more time. It's a little bit of disagreement. She'd go round and round and round until she got the consensus that she was looking for. And her view was that dissent was saved for matters of really the highest principle. Things that were so important, that's when you dissented. She learned that from another really terrific judge of the New Court of Appeals, Hugh Jones, former president of the State Bar Association, who wrote a famous article articulating that. And Judith had such a reverence for the institution and for those who preceded her that this was something that she really took to heart. This idea, when it was something, it went to the heart of our profession and the courts and the justice system, that's when you dissent. And when those kind of matters came before her, boy, did she rise to the occasion. She responded with great eloquence and passion and humanity. And I just give you one example. I could do so much on a majority and dissenting opinion, but this particular one, 2006, Robles versus Hernandez. And that's the same-sex marriage case, the landmark same-sex marriage case, and her landmark dissent in that case. And let me just read you a very small quote that gives you a sense of her writing style, how she thought, the simplicity, the elegance, straightforwardness. This again, Hernandez versus Robles, 2006. This state has a proud tradition of affording equal rights to all New Yorkers. Sadly, the court today retreats from that proud tradition. Fundamental rights, once recognized, cannot be denied to particular groups on the grounds that these groups have historically been denied those rights. In recasting plaintiffs' invocation of their fundamental right to marry as a request for recognition of a new right to same-sex marriage, the court misapprehends the nature of the liberty interest at stake. Simply put, fundamental rights are fundamental rights. They are not defined in terms of who is entitled to exercise them. Future generations will look back on today's decision as an unfortunate misstep. And Judith, as she was in so many things, was prescient because within a year, the New York legislature had vindicated her position, and of course, very shortly, the U.S. Supreme Court recognized this again, fundamental right to marry the person of your choosing. And that decision resonated, as so many of our decisions did. But this, again, this matter was so important to her. And she worked and worked on that decision. I know firsthand that was the case. And as always, her words were elegant and passionate with an appreciation of the human condition. Beyond her scholarship and conviction, her writing style was truly worth the price of admission. And she was an editor at heart from her newspaper days early on. And as I think it was Louisa would cover it, as a social reporter for a New Jersey community newspaper or something, she always talked about those days. So she was an editor at heart in the newspaper. And every decision that came out of the Court of Appeals, she would edit. It didn't matter hers, anybody else. And that was sometimes to the chagrin of our colleagues, but usually to their delight, because they knew that she made the decision better, and she made New York the premier high court in the country because of the quality of the work product that came out of that court. And so, in so many ways, she was a chief judge for the ages in terms of her presiding over the high court. And I can tell you, when we go to the meeting of the chief judges around the country, they adored her and they idolized her. On any issue that came up, it was always, let's see what Judith thinks. Let's ask Judith. I mean, I can't tell you the admiration that these are chiefs from around the country, rural, urban, one part of the country across to the other side. But that's only the half the story of Judith Kaye. The other half is the other role that she had as the chief judge of New York, the administrative role, running one of the most complex and largest judiciaries in the country. As with the famed Arthur Vanderbilt, i.e. Vanderbilt Hall, right? She was the great reformer. That was Judith Kaye. She changed the landscape of justice in New York. In so many ways, from professional ethics, where she had a whole new standard of conduct to the highest levels, aspirations of our profession that she put into effect, from treating matrimonial and family court cases and children in the courts, an area that had been neglected for so long. She put the focus on those cases. Problem-solving courts, drug courts, domestic violence courts, community courts, mental health courts. She changed the notion of what justice was about. We don't necessarily wonder about how many dispositions we get, whether we win or lose. The idea is to have better outcomes for people. When they come into the court, that's part of the mandate of the courts and the justice system, to improve the outcomes for the human beings who come into the courts seeking justice. She had a recognition that the ills of society, whether they be drugs or domestic violence or homelessness, ultimately end up in the courts of the state of New York. The court's the emergency room for society's ailments. Judith got that. She understood it, and she understood that the courts had to be interactive with the society around us. We can't live in a vacuum within the four corners of the papers that come before the courts. We have to understand that the courts are all about all these human beings who we serve, and all of the problems of society, again, are reflected in the courts. The jury system. Who remembers the jury system in the old day when nobody served, nobody wanted to serve? Judith Kay changed that to the idea that everybody serves, whether it be chief judges or mayors or governors, you served. And that is the highest form of civic duty. And the world changed around the country. Again, started a movement where all the jury systems around the country changed. And the other thing I'd mention is she also renovated the physical plant of the courts in New York, recognizing that courts should be temples of justice, that if they're decrepit and depressing, the public doesn't realize anything important happens there. If you want to have respect for the law, you have to have buildings that reflect the majesty of the role that the judiciary performs, that the courts perform. So Judith Kay got it in almost all respects, she got it. And she was truly a great chief judge and a chief judge for all seasons. And it is a fitting tribute tonight in the law school that she graduated from, that she so loved, that shaped her judicial philosophy and her whole tenure as a judge and as a lawyer, for that matter. What could be better than to be here with all of you? So to have this portrait hung in Greenberg Lounge is the ultimate honor. Bar none, I am thrilled to be here to celebrate with all of you the incomparable Judith S. Kay, the chief judge at the law school. Thank you so much.
With a capital T. I now have the pleasure of introducing my colleague and friend, Professor Melissa Murray. She is the Frederick I. and Grace Stokes Professor of Law here, and she's also the faculty director of our Birnbaum Women's Leadership Network. Professor Murray is a leading expert in family law and constitutional law with a particular focus on reproductive rights, sexuality in the law, marriage, and the legal recognition of caregiving. And her scholarship has been widely published. She is a leading voice in her field. She is a graduate of the University of Virginia and Yale Law School. And after law school, she was a law clerk for Judge Underhill in the District of Connecticut and for Sonia Sotomayor, then on the U.S. Court of Appeals for the Second Circuit. So please join me in welcoming Professor Murray.
Thank you. As the faculty director of the Birnbaum Women's Leadership Network at NYU Law, it is a profound privilege to be asked to speak about the life and legacy of one of NYU's truly amazing alumni. To be sure, NYU Law, which accepted and trained women law students well before many of our peer schools followed suit, has a long and very distinguished history of impressive and transformative alumni. But even in that glittering constellation of notable women lawyers, Judith Kaye stands out. A graduate of Barnard College, Judge Kaye came to NYU Law after she realized that there were few prospects going forward for a woman in journalism. Journalism's loss was the law school's gain. She matriculated at NYU Law as an evening student, working as a copy editor for a news service during the day while attending law school at night. At the time, she was one of just 10 women in a class of 290. I should note that today, the NYU JD class of 2025 is roughly 57% women. Truly progress. When Judge Kaye graduated in 1962, she was 6th in the class, and as Troy noted, she was immediately snapped up by Sullivan and Cromwell. But like many women of her time, her path in the law was somewhat circuitous. Again, after Sullivan and Cromwell, there was a stint at IBM's legal department, and during the time when she was raising a family, she also served as an assistant to the dean of the law school. She would later be hired at Olwine, Connolly, Chase, O'Donnell, and Ware, and become their first woman partner in 1975. Her path to the bench was also somewhat circuitous, and again marked by the inevitable impact of subtle and sometimes overt gender discrimination. In 1983, when a vacancy opened up at the New York Court of Appeals, the New York State Commission on Judicial Nominations submitted to then-Governor Mario Cuomo a list of prospective nominees. The list included no women. Shortly thereafter, another vacancy on the Court of Appeals emerged. This time, the commission's list of 7 candidates did include 2 women, a state Supreme Court justice who had formerly served as the president of the Women's Bar Association, and Judge Kaye. In what can only be described as a misguided but incredibly loyal tribute to its former president, the Women's Bar Association, in stark contrast to other bar groups, rated Judge Kaye not qualified. Exactly. No matter. After interviewing her twice, Governor Cuomo put aside the misguided views of the Women's Bar Association and appointed Kaye to a 14-year term on the Court of Appeals. Within a decade, she would be elevated to Chief Judge, the first woman to hold the position. Many have discussed the incredible impact of Judge Kaye on the Court of Appeals, including her commitment to expanding rights and ensuring access to justice for all. But I always think of Judge Kaye fondly each semester when I teach family law, and when I begin the semester with a little-known case, Braschi versus Stahl Associates. Judge Kaye was in the majority in Braschi, but she did not write the majority opinion. Still, her influence and her tireless pursuit and sense of justice are evident in the majority and concurring opinions. The case was decided in 1989. And it concerned the definition of family for purposes of New York's rent control ordinance. The case involved 2 litigants, Leslie Blanchard, who had secured a rent-controlled apartment in New York City where he lived with his partner, the second litigant, Miguel Braschi. Like many gay men living in the city during the 1980s, Braschi and Blanchard soon felt the sting of the burgeoning HIV/AIDS crisis. When Leslie died of AIDS in 1986, Miguel, who had been his devoted caregiver during his illness, found himself not only mourning the loss of a life partner, but also consumed with anxiety and worry that he would soon be homeless. Stahl Associates, which owned the rent-controlled apartment in which the couple had resided, moved to evict Miguel on the ground that because he was not a family member, a term the company defined narrowly to individuals related by blood or marriage, he was ineligible to remain in the apartment upon Leslie's death, as Leslie was the tenant of record. Miguel challenged his eviction, arguing that as Leslie's life partner, he was in fact family for purposes of the rent control ordinance. The appellate division disagreed, rejecting this on the ground that, quote, homosexuals cannot yet legally marry or enter into legally recognized relationships, and that the rent control regulations were intended to provide protection to those in, quote, traditional, legally recognized familial relationships. Miguel appealed the case to the New York Court of Appeals, where he found a more receptive audience. The Court of Appeals, in moves that would be reprised in many of Judge Kaye's own opinions, took a more expansive view of the statutory language. Family was not limited to the cabined understanding of the traditional family, but could encompass what the court termed two adult lifetime partners whose relationship is long-term and characterized by emotional and financial commitment and interdependence. Of particular importance to the court were the facts that Leslie and Miguel had not only had a long-term relationship, but their lives were completely intertwined. They were the beneficiaries of each other's insurance policies. They shared financial obligations. They were known as family members to each other's families. And in a move that was likely the most New York aspect of the case, the Court of Appeals noted approvingly that the pair was understood by their doorman as a family. It seems a relatively small thing, the recognition as a family member for purposes of one city's arcane rent control regime. But Braschi and its logic became the legal bedrock for same-sex couples seeking judicial recognition of their relationship and their rights. Well before Judge Kaye's blistering dissent in Hernandez versus Robles, she, as part of the Braschi majority, laid a foundation for a more expansive and inclusive understanding of the family. When I served as a law clerk to then Judge, now Justice Sotomayor, our chambers had the pleasure of having lunch with Chief Judge Kaye, with whom our own judge enjoyed a warm friendship. As we sat around the table in chambers, I remember asking Judge Kaye about the Braschi case and its path-breaking view of the family. What had influenced her thinking? How had they arrived at the view in 1989, when few courts were thinking in this way, that two unmarried men were a family? She laughed at my naivete and then pivoted to her own experience as a working mother. As she explained it, for many at the time, her own family situation was not the norm. Working mothers were still somewhat unorthodox, and she had relied to some degree on external help from family and friends. With that experience in mind, she said, it was easy to imagine the various ways that individuals might organize themselves in the service of their intimate lives. And her own experiences butting up against convention paved the way for her to disrupt these other conventions in the service of a more just world. I mention all of this to underscore that while Judge Kaye is a hero to so many women in the law, someone on whose shoulders we all stand, her impact extends far beyond the fact of her being a pathbreaker in New York and in high courts across the country. And there's so much wisdom, as Judge Lippman says, in Judge Kaye's writings. But for me, the most useful wisdom that Judge Kaye imparted was this. In a 2012 conversation with another pathbreaker, Justice Sandra Day O'Connor, Justice O'Connor asked Judge Kaye about the best decisions that a woman could make regarding career and life. And Judge Kaye responded with characteristic frankness and humility. The only advice I've ever felt comfortable giving across the board about anything is this: never buy a wrap skirt. Everything else is nuanced. Truer words were never spoken, and I have never purchased a wrap skirt. So again, thank you so much to the law school for honoring Judge Kaye in this way, and to Judge Kaye's family, thank you all for sharing her for so many years with all of us. Truly appreciated. Thank you.
I will make a note of that advice. Before I make my final introduction, I just wanted to say a few words for those of you who are not NYU alums to talk about the importance of this room. This is Greenberg Lounge, and it is the place where we recognize great figures who are connected to the law school. Chief Judge Lippman mentioned Arthur Vanderbilt, who was dean of this law school and later Chief Justice of the New Jersey Supreme Court. He's hanging on that wall over there. And you can see that he was someone you had to pay attention to, right? My predecessors as deans are along the walls here. My former late great colleague, Derek Bell, is over here. Fritz Alexander from the Court of Appeals, an NYU alum, is also over there. So the decision to include Chief Judge Kaye in this wonderful group of significant figures in the law is extraordinarily powerful. So I'd like to introduce now Louisa Hagemeyer. This is poignant for us because Louisa is both an alum of this law school, where she graduated magna cum laude and a member of the Order of the Coif, but she is also Chief Judge Kaye's daughter. And we're really happy that she could be with us here today. So I would invite her up for a few words.
Thank you so much, everyone, for being here. There are so many people here who my mother loved and cherished, and she would love to be here tonight. I didn't really prepare any remarks. I just wanted to thank all of you. Thank you, Dean. Thank you, Professor Murray, and thank you, Chief Judge Lippman, for your beautiful remarks. And I was hoping that you were leading up to the rap skirt. Because that's absolutely true. That was her recommendation to everybody, if male or female. So my mother, as many of you know, was sort of a prodigy. She skipped 3 grades at a very, very young age. I think she went from 1st grade to 4th grade. So, you know, she was like sort of a weirdo for a lot of her life. And I don't think she ever felt like she was home and like she fit in until she got here. And she really did love this law school so much. It was really her center. And I have to say, I feel the same way about NYU. I don't think I ever felt like I fit in and like I was in my right place until I got here. So it's a cherished place for our entire family. And my mother is in the company she would have chosen tonight amongst all of you, and she will dwell now here amongst company that she would have chosen in Greenburgh. So thank you so much, NYU Law School, for commissioning this. Oh, and I forgot Trevor. Is Trevor here? I think he was going to be here. But to Dean Morrison, thank you for initiating this project. And I cannot wait to see the portrait, although I guess we all got a little sneak peek. And it's amazing, and it looks just like her with her sort of little wry smile. I love it. So without further ado, I guess we're going to see the real thing.
Thank you, everyone. We have drinks and refreshments. Please stay and enjoy the food, the drink, and the company. And Chief Judge Kaye's portrait is probably going to hang over there. And I hope to see you all back here again in the future to see this fantastic portrait here in Greenburgh Lounge. Thank you. Good evening.